from the district understands the needs of their community.
Okay, so the unfortunate side effect that a couple of incumbents end up in the same place once in a while is...
That's part of...
That's the way it goes.
It goes, exactly, because the population does shift.
Okay. Okay, thank you very much. Members, any other questions? All right, let's just double check. Okay, let's go ahead and move on to the next bill, which is HB 201. This amends the campaign finance laws in a number of ways, mainly technical in nature, so I'll leave it at that. First up is Campaign Spending Commission. Good afternoon.
Good afternoon, Chair Rhodes, Vice Chair Hart, and members of the committee. I did submit testimony, and I guess the only part of it that I want to emphasize is that we actually submitted this bill to
Can you pull the mic a little closer? Thanks.
We actually submitted this bill to the Senate President for introduction. We were instructed to do that. And I guess when it was being transmitted to the House side, Section 4 of what is now in SB 555 was left out. So, of course, we'd like to see that back into the House side. And it's basically it's just a correction to it's a miscitation of the Hawaii revised statutes. It's not anything substantive.
Okay.
Thank you.
Thank you very much. Next up, we have League of Women Voters.
Mr. Chair, Ms. Vice Chair, and members of the committee, the League highly supports this measure. Much of it is housekeeping. We do find raising the limit of spending for the prosecutor to $1.40 per registered voter perfectly reasonable. And we want to acknowledge at this time the excellent work done for the public with the Campaign Spending Commission website. The data that is available there is increasingly easy to use and increasingly relevant, and we're very pleased that it's adding this transparency to the campaign spending process.
Okay, thank you very much. Next up, we have Common Cause. In support. Next, we have Americans for Democratic Action, also in support. And that's all the written testimony we had as of about noon. Anyone else wishing to testify on HB 201? Seeing none, members, questions? Just double check. Campaign Spending Commission, you want to come back? So just to clarify for everyone, just a straight reading of the bill, it would appear that the bill seeks to increase the frequency of supplemental reports by deleting the phrase after an election year. But that's all. Just describe what's going on right now. We already are required.
What's going on right now? All of the candidate committees, as well as all of the non-candidate committees, file that report on January 31st of every year. And it's built into our electronic filing system, and I was informed that that was the case even before the electronic filing system, where January 31st of every year a report would be filed. So we're not, I guess it's how you look at it, but we don't believe that
we weren't actually required to file it at those points, but we have been anyway, so this doesn't really change anything.
Right, it doesn't really change anything. For example, on January 31st of 2012, all the candidates filed the report. We did have two non-candidates that didn't, but I couldn't go after them because of the language in the law. But that's Section 7 dealing with non-candidate committees.
So just a note to the other committee members, this is January 31st after an election year, so anyway.
Yeah, this one can be enforced.
This one can be enforced. Also, I had a question about the requiring non-candidate committee reports to state contributions made in addition to contributions received. Can you just go over the non-candidate committee provision a little bit?
Yeah, the way the law currently reads, it only speaks of contributions received by non-candidate committees. In actuality, non-candidate committees also make contributions to candidates, and you know, we require that too. So they report on it, but so we just want to match the law with what actually happens.
Okay. Does this have any Citizens United implications because of the independent nature of the expenditures? Is somebody going to claim they don't have to adhere to this scheme?
You know, they might, but basically what you're looking at in our bill is a reporting requirement, and the reporting requirements have been upheld by the courts. Yeah.
Okay. Okay. All right. Thank you. Members, any other questions? Okay. Seeing none, let's go ahead and move on to HB 198. This bill adds language to the absentee ballot law clarifying where the absentee ballot is to be mailed. Right now, when you apply for your absentee ballot, you have one address, and when you register to vote, you have another. So this would require that the absentee ballot be mailed to the voter's most recent voter registration form address. In other words, if you sign up for permanent absentee ballots and then you move, there are two separate addresses that they can conceivably send you the ballot. This would make it so that they send it to the one where you've just recently re-registered, and you would continue to get the permanent absentee ballots. All right. First up is State Office of Elections.
Was that under written testimony in support?
In support. Okay. Next up we have County Clerk Kauai. In support. Next we have County Clerk of Maui. Also in support. Next we have County Clerk of Hawaii County. Also in support. Next we have the League of Women Voters.
Mr. Chair, members of the committee, League of Women Voters isn't entirely sure we interpreted this bill correctly, and we were struggling with what should be a kind of a straightforward procedure for mailing absentee ballots. We know that in most cases, if somebody's registered to vote permanent absentee, the Office of Elections mails their ballot to the most recent address that's on record. We also know that the U.S. Post Office doesn't forward the ballot if it's returned for any reason. But we know that sometimes a permanent absentee voter will be temporarily away from the address on record. And we thought this bill was about addressing what should happen when that occurs, if they are temporarily away. This could occur either at the time a voter first registers to become permanent absentee, or it could occur for somebody who's already registered to be an absentee voter. Again, maybe we misinterpreted Section 15.4 because we thought that was addressing temporary mailing addresses for those who have permanent absentee status and no change was needed in the procedure. There's no change recommended in the bill. We thought the bill was about proposing mailing instructions for situations where the voter is completing an initial affidavit application for permanent status, knowing they would be temporarily away from their home where the absentee ballot is usually mailed. We thought the bill provided that when this happens, the voter, at the time they're completing the permanent absentee affidavit, had to simultaneously prepare a temporary mailing authorization, so there would be no confusion about where the ballot was to be mailed. Thereafter, the absentee ballot for the permanent absentee voter would go to the address listed on the voter's most recently completed application. Maybe the language in this measure could be improved somehow, because we think the basic idea is a very good one. It would avoid frustrating applicants for permanent absentee voting who know they'll be temporarily away from home when their ballot is delivered and who want to receive their ballot at their temporary address. This is actually an important step in making Hawaii's permanent absentee voting procedures more clear, and it's particularly important as we move forward with vote by mail. Making the changes in the bill clear and passing the bill would provide additional service for voters, and so we support the measure.
Okay, thanks very much. Anyone else wish to testify on HB 198? Seeing none. Members, questions? Representative Thielen.
If the Office of Elections could come up. Tell me how the office tracks the situation that a voter requests a permanent absentee ballot and then they move to another house. Is the voter required to notify the office, or how is that tracked?
Well, the voter has to first re-register, and then also provide that address. They have to provide another permanent absentee application.
So they actually have to do the process over again.
Yes.
Re-register at the new address
And update their permanent absentee registration. Permanent absentee application.
Okay, and then if that voter has the permanent absentee ballot, does this language allow them to contact you to say, I'm going to be out of town, send it to Kansas?
No, what they would do is they would fill out a seasonal absentee
They
application.
fill out a what?
A seasonal, the one for one election only. So we're
I've never seen one of those.
currently we have two types of application for absentee. You have a seasonal where that's this election I'm going to be out of town, and then you have a permanent where your ballot just gets mailed to you every election.
I've never seen a seasonal absentee ballot application.
That was
Are they up at the lieutenant governor's?
yes. That was the absentee process we had prior to the last election where permanent absentee was passed.
Well, I know the permanent absentee, but I don't know
prior to
the
the
so-called
last
seasonal.
Yeah, prior to the last election, every election you had to request an absentee ballot.
Well, I know that, but we took care of that.
No, but you still have that on. You still can use that process too. Permanent did not replace seasonal absentee applications.
Yeah, you can apply. You can apply for either one. You can apply just for this election, or you can apply permanently.
And it is, but is there just a box you tick?
No,
or
it's two different forms.
One's
or
red and
it's
one's
a
green.
separate form?
Yes.
Okay, but then a seasonal wouldn't really do the answer of a person all of a sudden realizing I'm going to be away for that election.
That's like if they were traveling abroad or something. That's when you would fill out the seasonal. So for just that election, the ballot would get sent to wherever you're traveling.
Okay. Can you provide the committee with copies of the seasonal?
Sure.
Thanks.
Okay.
Yeah, thank you.
Anyone else? Seeing none, I have a couple questions for you. So, responding to the League of Women Voters' concerns, I mean, I don't know. It looked okay, the language looked okay to me. Maybe you should come up too, so we hash this out. Because if I'm reading it correctly, okay, the absentee ballot for a voter requesting permanent absentee voter status shall be mailed to the mailing address contained on the voter's most recently completed affidavit on application for voter registration. Okay. Then a permanent absentee voter shall be responsible for providing a written authorization to the clerk to temporarily mail a ballot to an address different. That's what we were just talking about with Representative Thielen. So, what was the specific language that you were concerned
We were
with?
struggling with what happens if the voter is registering to be a permanent absentee voter for the first time, knowing they were going to be away from their permanent home for a temporary period.
So then what would they have to do? They'd have to file the registration form. They'd have to file the permanent absentee, and then they'd have to file a temporary one for that.
For seasonal.
So you'd have to fill 3 forms out. But I think the language reflects that. At least that's my read.
Yeah, the permanent absentee wasn't meant for people who are abroad or traveling or not going to be
Right.
home. It was meant for people who just request an absentee ballot every year to their residence address or their mailing address.
But the temporary stuff doesn't come up in here because it's not changed. Is that correct?
Correct.
Okay. Okay. Yes, go ahead, Representative.
Thank you. Is the term seasonal the seasonal absentee ballot application, is that on the ballot application?
It's a one-time only, so it has like an address where you would put where you would have your ballot sent.
But does it say seasonal? Because I'm
It
thinking...
says absentee, but it's just an absentee request, and then the other one is a permanent absentee request.
Well, then possibly the problem is line 19 on page 3. Because whatever that animal is that you actually have that you're going to show us should be referenced here on page 3, line 19. Because the written authorization sounds like I send you a postcard.
Well,
And that wouldn't be adequate.
you don't have to request an absentee ballot on a form as long as you provide the information that the form requires in written format, and you sign it, for example, your address, all the information that's on that form. It doesn't have to be on that form to request an absentee ballot. As long as that information is provided to the clerk's office, they would process it.
Well, I guess I'd be a little bit concerned about veracity on that kind of thing. I mean, what would stop, for example, my colleague for signing my name and sending in a request to have my ballot sent down?
The signatures are actually checked, yeah.
Anyways, that's really no problem.
No, when you turn in an application, your signature is actually checked with the signature on file.
But you're saying you can just do it by a postcard or a letter?
Not a postcard, but a letter containing all the information that is on that form. I believe the law says that as long as this information is provided, it acts as a... The form is just a courtesy for you to easily fill out to request a absentee ballot.
Yeah, but I'm sorry. But then go back to line 19. It says...
Written authorization.
That sounds like a letter. I mean, it should be something a little bit more official so it has the truth requirement.
It's official. Yeah.
And I guess the sworn statement that we all do.
The League of Women Voters is sure that the Office of Elections is trying to make it possible for everybody who's temporarily away to receive their absentee ballot, and we're really pleased about that. But we still feel this is somewhat confusing.
If you go to the beginning, like subsection A, it just says you can request by writing. Any person registered to vote may request an absentee ballot or permanent absentee ballot in person or in writing from the clerk at any time, but not later than 4:30 p.m. on the 7th day. So that just tracks that language.
Okay.
Thank you.
Any other questions? Okay, let's go ahead and move on to the next bill, which is HB 300. This requires information to be provided by the Chief Election Officer for proposed state constitutional and county charter amendments in published pamphlet format and electronically on a website 30 days before each election. First up, we have Office of Elections. Next up, we have County Clerk Kauai, also with comments. Next, we have County Clerk Maui. Excuse me, just 1 second. Okay, there's the permanent absentee.
And where's the season?
Yeah, I don't have one. Okay. Anyway, there's another form that's just like this, only it's red. But I don't have one.
It doesn't say seasonal on it.
It doesn't say seasonal.
It's just the regular absentee ballot.
Sorry.
So each time, if you're only going to do it for that one election cycle, you will.
I think.
I'm sorry. So next up is next up is County Clerk of Maui. In opposition, next is Councilmember Stanley Chang. In support, next we have League of Women Voters.
League of Women Voters strongly supports this measure that would require the publication of information on proposed constitutional amendments or proposed charter amendments. We believe that many voters are completely unaware of the proposed constitutional amendment or proposed charter amendment before they go to the polls. Truthfully, that's really in large part their own fault. But recently, the Hawaii County of League of Women Voters staff voter registration tables at our Kona Kmart. In preparation for this, we also prepared our own leaflet that listed the ballot issues with short pros and cons. This is in Hawaii County. We handed them out to everyone that appeared as they came to register and as they left the store. We found that almost no one knew that there were issues on the ballot. Unfortunately, since the League has no money for widespread distribution of such information, we can only give out our limited supply of pamphlets at the time that we're registering people or doing voter education. After the election, we had feedback from some poll workers who complained about how long it took people to vote because they had no idea there were ballot issues or charter amendments on the ballot. They also had no idea how to vote for them on short notice. This year, there was also very limited coverage of the ballot issues and charter amendments by the press. The ballot and charter education should explain to the voters what each proposed change means in simple, everyday language. Additionally, pros and cons for each change should be presented in a factual, nonpartisan manner. We think this is an appropriate duty for government, and we think there's much benefit to all of us for government to do this for us. It would be much better than having the League of Women Voters do this. In the past, the Office of Elections prepared such voter education materials, but in recent years they stopped doing this. We would like to see it in both online and paper formats. What can be more important than an informed electorate? We strongly support passing this bill. And thank you for the opportunity to testify.
Thanks very much. Next up, we have Common Cause, Hawaii. In support. Next, we have Nancy Devlantes, also in support. That's all the written testimony we have. Anyone else wishing to testify on HB 300? Okay, members, questions? Representative Parr.
Thank you, Chair. Mr. Nago. Good afternoon, Mr. Nago. Thank you for being with us today. I know that you stood on your testimony, but I think it's very important for members of this committee as well as those watching us in TV land right now. Explain to us exactly the history, because I thoroughly agree with all of Ms. Mason's comments. The fact of the matter is we have all these constitutional amendments that are going to the voters, and personally my constituents call me up all the time and they're like, I don't understand this, and that's why I think we have such a high rate of people just leaving it blank, not because they support or against it, and again, for those of us who know, a blank means a no vote, and I think that's why we're having such a problem with some of these actually very good amendments, because people don't understand them. So you've heard the comments of the League of Women Voters, so let's go back and talk about the historical background. You talked about LRB once doing this, and talk about what the pros and cons were, because I think it's important for people to understand, especially now that we have Capital TV on us right now.
Well, prior to, I don't know what year, but LRB used to do the digest, the pros and cons. It then got transmitted to us to translate and disseminate. However, after 2002, there was a lawsuit, Watland versus Lingo, and then the law got changed in 2003 to take out the requirement for the creation of such a document. So there was no statutory requirement anymore to produce that. Basically, the legislature just provided us the full text of the bills, and then we provided us the full text of the bill with the translations, which we had in the polling places. But once LRB was not charged with doing the pros and cons, that stopped.
Okay, let's take a step back. It wasn't pros and cons, correct? It was just educational materials.
Well, it was
because
meaning of a yes vote. A yes vote means
the implications of a yes vote or implications of a no vote. Okay. So that being said, now you talked about this Hawaii Supreme Court case, Watland versus Lingo. Let's talk about that, because it says here, the Hawaii Supreme Court found that the state had not published the text of a proposed constitutional amendment in 2002 as required by the Hawaii State Constitution, and as such left unaddressed plaintiffs' second contention that LRB's materials were incorrect and should serve as a separate basis to reverse the ratification of a proposed amendment. So are you saying that based on that case law, that's why the Office of Elections now has decided, well, again, because now clearly, based on this, the ruling in this case, it now puts some kind of liability on the state?
No, it used to be if memory serves me correct, it used to be in statute or that the LRB would create the digest and we would distribute it.
Okay.
After this lawsuit, the law got changed where basically there was no requirement for any kind of digest to be published by the legislature anymore. And it also put the printing requirement, which was the basis of that Watland thing with the legislature. So all we had to do, all the Office of Elections had to do was have it in the polling place, the full text of the bill in the polling place.
Okay, so when you say the full text, you're talking about not educational materials.
No, it's just the bill.
Literally
itself,
the
bill.
actual constitutional amendment that's being posed to the voters.
Yes.
Okay, so let's get to this second part of your testimony, your written testimony about deadline to submit English and translated summaries of proposed amendments. You know, you have here, we would propose that an additional subsection C be added to the proposed HRS 11-A, which would say the following: the legislature or county council, in regards to a charter amendment and preparing the summary, will ensure that it is translated into the covered languages required by the Voting Rights Act, and it will provide the summary in the Office of Election by the 19th day prior to the general election. So can you just give us some of the background? I know that the Office of Elections does in fact translate ballots into certain languages, or you actually you provide it.
The actual text that's translated regarding constitutional amendments is provided to us, translated by the legislature and the counties for charter amendment.
Okay, so all you do is really just print it.
We distribute it.
You distribute it. Okay. So your concern now is if this bill were to move forward, then you would ask that
It be provided in a timely manner so that we could get it ready for distribution.
okay, and also in the other translated language.
Yes.
Okay. And then let's go to hyperlinks to legislative history. The bill seeks for hyperlinks to exist to testimony associated with the proposed Conn amendment or charter amendment, and for the Office of Elections to distinguish for internet users whether testimony refers to a previous draft of a proposed amendment. We would suggest that the legislature and county councils are in the best position to understand the legislative history of the bills that resulted in the proposed constitutional amendment or charter amendment. As such, we would recommend that the bill be amended to provide that the legislature and the county clerks provide the Office of Elections a specific link to their website. So you're asking, if this bill were to move forward, you would want a link then to the legislature's website,
Correct.
not the Office of Elections website, basically discussing or providing educational materials.
Yes.
Okay. Finally, the most important thing, the appropriation. Okay, you say that if this bill were to move forward, you're requesting an appropriation of $180,000. Can you please explain what is the justification of that cost?
Well, previously we used to distribute a Hawaii Votes brochure. That was a brochure sent to each household statewide, basically explaining the what, when, where, how to vote. This number is based off of what we've spent previously and updated to what it would cost if we had to send a brochure of our digest to each household. So that would basically be postage and printing to approximately 374,000 households.
Registered households.
Or a household with a registered voter in it.
Okay. So, but that number would be fluid, right? Because depending on the number of registered households in an election cycle,
Yes.
that could change.
But I don't believe it would change by very much.
Okay, so you've heard the testimony of the League of Women Voters. I mean, there's got to be a solution here, because we as the legislature, we spend a lot of time trying to get these constitutional amendments onto the ballot, and at the end of the day, the issue really is education. We just need to educate our voters, and so I completely agree with everything that Ms. Mason has said, and I understand the problem, the conundrum that you folks are in, but there's got to be a solution other than just saying, okay, legislature, you could do it. I mean, you're the Office of Elections, they're the League of Women Voters. We've got to figure out a way in order to get this information and to educate our constituents.
And I agree with you that education is important. One of the issues that we face is coming up with the pros and cons. What a yes vote means, what a no vote means. I mean, in 1998, we got into trouble with the that same-sex marriage amendment. We got criticized for that. That was LRB. We didn't do that. We just distributed, but we got threatened with a lawsuit about that. So it's a matter of how you write it, that digest. I mean, we'd be happy to distribute it, but for us to come up with the pros and cons, would be a little difficult for us.
I'm still wary of the words pros and cons because I just don't think it's about pros and cons. I think it's about, it can be very objective information. For example, the Khan Amendment that failed this year allowing judges to come back, retired judges who were forced out at the age of 70 to come back on a temporary basis. They could come back for up to 3 months. They wouldn't be allowed to be at a level higher. I had people calling me up every day, my constituents asking me about that, and I explained to them, well, there was a constitutional amendment, and when I explained to them the background, that the people of the state of Hawaii mandated that judges retire at the age of 70, and therefore we're now dealing with a shortfall, and so this is what we're trying to do to address that. And so to me that wasn't a pro or the con, it was just kind of providing the background as well as the educational information. I wasn't advocating either way because I don't want to, I'm not trying to influence my constituents, I'm just trying to explain to them what was the purpose of the amendment. And so I just figured there's got to be a more simpler solution. It shouldn't be so difficult about, the pros and cons, what it means to vote yes or no. It should just be very straightforward, objective information about the background, the history, the historical background, and the reason for the Khan Amendment being presented to the voters.
I understand like I said in the past, what we thought was objective would get criticized by one side or the other because they didn't like their chances. It's just.
You think that then essentially, if we were to go back to that way, we would be just subjecting the state to liability?
No, I'm not saying that. I'm just saying if you could get a third party to draft the objectives that everybody can agree upon, it would be beneficial to everybody. But the way those things were written in the past led somebody to always question whether or not it was a truthful, objective statement.
Okay, I tried. All right. Well, Ms. Mason, if you want to come up and anybody else has questions, I don't know if you can address that, Ms. Mason, with respect to objectivity.
We see Hawaii as a place where we can have the best election practices in the country. Providing this kind of information for ballot amendments and charter amendments is standard procedure nearly everywhere in the country. And I know that Mr. Nago recognizes this is a best practices thing to do for the voters. As to who can prepare a disinterested explanation, the League really doesn't know which government agency is best equipped to do this. We do think when the analysis is done, it should be made available through the Office of Elections because that's where the typical voter would expect to find it. It should be available through their office.
Janet, what are other states doing to deal with this problem?
California is the one I'm most familiar with.
Okay.
They have a newspaper-like publication on ballot and charter amendments that is mailed to every household, and it's excellent. And I believe it is prepared by their Secretary of State's office. I'm not sure. If the Office of Elections feels that they need a more disinterested draft of such material, they should come ask the League of Women Voters. We try and do it every year, but the average voter may not think of us when they're trying to understand these charter amendments and the ballot changes. This is important, and we heard testimony the other day from the State Attorney General that over the past 10 years, 15% of the people voting left the ballot blank. And given the fact that we already have a low voter turnout, that means it's relatively easy to pass any ballot amendment or charter amendment. It's relatively easy. We don't think this is a good situation. We're not opposed to constitutional amendment changes, but we don't think it should be done lightly. And we think everybody should be provided this as a basic service.
Okay. Members, any other questions? Representative Thielen.
I was just going to weigh in on that. You're basically saying you don't want to do it.
We don't want to create the The digest is what it was previously called, which would say the impacts of a no vote. Basically, that was done by LRB in the past, and it went through the testimony. What they did was they called through the testimony when the bill was being heard, and that's how they came up with the impacts of a yes or a no vote, or what it means. I don't think it would be appropriate for our office to do that, because we do the elections.
But an election, by its own definition, is supposed to be run in an impartial manner. So that's why I would think that you would be the obvious place to be tasked with doing this.
But I guess constitutional amendments are kind of like a candidate. I guess is a candidate and knows a candidate, and to come down either way, to be seen as coming down either way would not be impartial.
Well, no. I mean, what the League of Women Voters is saying is that the voters need more information on this so that they then are going to go ahead and be able to vote on these amendments. And if there isn't any other branch of government really here that's supposed to be as impartial as your office. So, I mean, you can't go to, like, the Attorney General's office, because the Attorney General is part of this administration, and that's partisan. And so your office is the one that's tasked with holding nonpartisan types of elections. So I don't see why, I mean, obviously this probably goes to finance. I didn't look at the referral, but if it's a matter of having to have a financial, having money go with the bill and the requirement to do it, I don't understand why you just aren't the obvious one to do it. You personally may not like it, but you're not always going to be there, and you weren't there before, and I think others have done other things in that office, and so I just don't understand your reluctance.
No, I can't remember a time when the office actually produced the digest. It was always the Legislative Reference Bureau that produced it, and we distributed it. And we would not be opposed to that kind of agreement or working relationship or whatever you might want to call it.
So you want it to be LRB, but you don't want it to be you?
Correct.
Your office?
Yes.
You presently, I mean, that doesn't mean that future heads of the Office of Elections wouldn't welcome that and maybe even form a link with League of Women Voters. So
yeah, I can't speak for future.
So that's just your personal.
It's one of those.
I'm sorry, let me intervene. Let me interject here. So if I'm reading this right, on page 3, line 5, an accurate summary that is reasonably understandable for the average layperson explaining the content of the proposed amendment without supporting or opposing the proposed amendment, provided that the summary shall be prepared by the legislature in the case of a proposed amendment to the state constitution, or the county clerk or the county clerk's designee in the case of a proposed amendment. So you wouldn't actually be preparing it under this language.
Correct. We would just be disseminating.
Just disseminating. But you don't have any problem with disseminating.
No, we don't have a problem with disseminating.
Okay.
Unless we had a third kind of a question that wasn't one of those two categories.
What
But
else
that's
would it be?
okay.
Okay. I'm sorry. Are you finished?
Okay, no, that's fine.
Okay. I have two down here. Representative Brower.
Yeah, just to each of our guests. When there's a city charter amendment, doesn't the city mail us information about that?
Yes, but I'm not sure who prepares that.
Yeah. So I think we should just model ourselves after what the city does for their charter amendments.
Okay. Thank you. Representative Dermott.
Yeah, Scott, just to recap, we took us about 45 minutes to get there. You're happy to disseminate the information. You just don't want to be in charge of the verbal jiu-jitsu to put it together because that's not your skill set.
Correct.
All right, good.
Okay, anyone else? Okay, seeing none, I'm going to pass the gavel to Vice Chair Har for the next few bills.
Okay, thank you, Chair. Moving on to House Bill 300 relating to informed voting. This would, House Bill 206 relating to mandatory ethics training. This would require that all employees whose financial disclosure statements are public complete a mandatory ethics training course. Allow State Ethics Commission to hold ethics training at times of the year other than January, and repeals minimum duration of the ethics course. First up, we have the State Ethics Commission.
Good
afternoon. My name is Susan Yoza. I'm the Associate Director for the State Ethics Commission.
Good afternoon.
We strongly support this bill. We believe that by expanding the group of high-ranking state officials who are required to attend a mandatory ethics training class, the bill will instill a greater awareness and understanding of ethics at the highest levels of state government. This bill will also provide our office with greater flexibility in scheduling and conducting the class. Currently, the law provides that the class must be held in January and must be 2 hours in length. It's been our experience that scheduling conflicts for many officials exist in January with the convening of the legislature and the pre-session budget briefings that many state agencies are going through. And so what this bill does is to provide that the class may be held at other times, and it also drops the 2-hour requirement, which we believe is a good idea because this will allow for the length of the class to be adjusted as necessary and appropriate. So for these reasons, we strongly support this bill, and thank you for allowing us to testify.
Thank you, Ms. Yoza. Next up, we have Common Cause Hawaii. In support, Americans for Democratic Action. In strong support, Nancy Dablantes. In support. That's all the written testimony I have on House Bill 206. Are there any other persons wishing to testify? If not, members, any questions? Representative Cavanilla.
One from the State Ethics Commission. Should this bill passes, what would be the additional cost of it?
Given the scope of the bill in its current form, there will be no additional cost, so we're not asking for any additional financing for it.
All right, that's good to know. Thanks.
Thank you.
Thank you. Members, any other questions? Seeing none, moving on to House Bill 148, relating to cruelty to animals. This establishes a felony and misdemeanor offense for injuring or killing an animal engaged in law enforcement or corrections activities. First up, we've got the Department of Public Safety, Ted Sakai, or his designee. Thank you, Mr. Kamita. Office of the Public Defender, Tim Ho. Good afternoon, Mr. Ho.
Good afternoon, Vice Chair Har, Chair Rhodes, and members of the Judiciary Committee. Timothy Ho, Public Defender's Office. Our office stands in opposition to this bill. Notwithstanding the emotional attachment that the handler of the law enforcement animal will develop like any other pet owner with their animal, we believe that the law enforcement animal is a tool of law enforcement, and therefore to carve out a separate cruelty statute for these animals, we believe is wrong. The statistics cited of 139 dogs killed over the past 40 years comes out to about 3.5 dogs a year. In contrast with the amount of police officers who lose their lives. According to the National Law Enforcement Officers Memorial Fund website, over the past 10 years, it amounted to 1,559. So when you contrast the statistics, 139 dogs over 40 years may seem like a lot, but we would say that I would find surprisingly low per year. The submitted written testimony shows that there's a possibility that somebody who is wrongfully targeted by a dog may instinctively strike out if the dog is biting that person's leg. And while not guilty of any crime, would now be facing a possible felony for striking or responding in what is in a way that would be an instinctive response. Furthermore, we would ask that if this bill is passed out of committee, that an amendment to this bill, and I saw the prosecutor's testimony, and I think we agree that page 4, line 21 and 22 should be omitted because it would be nearly impossible for an animal to testify that they suffered pain or injury. And so cruelty to a law enforcement animal in the second degree would read that then be defined as recklessly causing bodily injury to or death to a law enforcement animal, and that first subsection would be removed. Thank you.
Okay, thank you, Mr. Ho. Moving on to the prosecuting attorney's office, Mr. Karmatsu.
Thank you, Chair, Vice Chair, members of the committee, John Karmatsu, Deputy Prosecutor, Honolulu. For us, we're not taking a position. We have comments, though. If you could turn to page 4, line 13, I believe, you know how we had that conversation yesterday on disjunctive versus conjunctive? Looks like the legislative intent here would make the disjunctive actually, you guys meant conjunctive, right? Where the or means and, right, in this situation. So just to be clear, make it and, just to show that it could be any of these situations where you have veterinary bail, replacement costs, lost wages, and any other costs. Also, line 21 for page 4, injury is not defined, so there's a question mark on that. And pain under the criminal code is actually, in this situation where you have a dog who can't speak, it will be challenging, but we'll have to have a witness that testifies to show beyond a reasonable doubt that the dog did in fact feel pain based off of that witness, third-party observation. But it will be a challenging, but it's, I've seen assault 3 cases win with that, but it'll be challenging. But we just point that out to you guys. And lastly is a definition for the dogs under law enforcement. We have our dog here, courthouse dog. Wouldn't be qualified though under law enforcement since the handler and the dog itself, herself, is actually working for the victim witness advocate. But if possible, maybe include courthouse dogs. They have been very helpful with helping with our witnesses. Thank you very much.
Okay, thank you very much, Mr. Karmatsu. Honolulu Police Department, HPD.
Chair Rhodes, council members, committee members. I would just like to say the Honolulu Police Department supports this bill. My name is Assistant Chief Left Court. The reason I'm here is our SWAT team had to go out on a case where somebody had burglarized a house and ran into the field. So the dogs had to go out there to help to locate this person. Our major and our captain, who would be the ones testifying, are engaged. We support this bill because the dogs are the partners of the officers, and they go out there and put their lives on the line just like the officers do. And as there are protections relating to officers and when people attack, these dogs are doing the job with their handler in tow, so that if somebody did have to testify, they would be able to, the handler would be able to say the dog was injured, and then you'd have the medical people to back it up. But they are not more important than other animals, but just doing a job, just like a police officer isn't any more important, but they're doing a specific job in order to protect society.
Okay. Thank you, Assistant Chief Left in Court. Maui Police Department. In support, Kathy Gogo, Animal Rights Hawaii. In support, Teresa Parsons. In support, Mary James. In support. That's all the written testimony I have on House Bill 148. Are there any other persons wishing to testify? If not, members, any questions? Chair?
Mr. Karmatsu, can you please come back up? You had some comments about. I just want to be sure I got them. It was on page 4, line 13, I guess. You're saying that should be an and?
If it's the intent of the legislature that it's conjunctive, because sometimes some disjunctives look like we can interpret it as conjunctive.
Okay, so in addition to any penalty imposed for a conviction under this section, the court shall order the defendant to make restitution to the applicable law enforcement or corrections agency or any other person who owns the law enforcement animal for any veterinary bills, replacement costs, lost wages, or any other costs.
If you look at our 706-646 restitution statute, we put there's an and on the various things that can get restitution. Yeah. But I think in this case, you know how we're talking about disjunctive, conjunctive, how you guys' intent might be actually, it could be all of these, right?
Any or all is what you're after, right?
So exactly what we had discussion yesterday.
Okay, and then there was, the other one was about the pain the dog felt. So you think you have a way to prove the pain?
Well, in the criminal code, bodily injury is defined as pain, yeah. But here you guys are creating a new word, injury or pain. I guess if you guys could define that. For pain in court, we have to, usually we have the victim that's testifying, but we can also use a witness that observed the pain that the victim suffered.
Okay, thank you very much.
Okay, members, any other questions? Seeing none, moving on to House Bill 238 related to witnesses. This amends section 620. Sorry. Oh, Representative Caminilla, I'm sorry.
Yeah, the policeman, please. Police officer.
Assistant Chief Lefkencourt.
If I'm being chased by a dog, whether it's any kind of dog, I would have the reaction of, wanting to hurt the dog if the dog is wanting to hurt me. So what instance are we referring to in the bill wherein such a person is going to receive misdemeanor offense for fighting with that dog? Give me an instance.
Well, let's say you're being chased by a police officer and you turn around and punch the police officer. We have rules that would give you...
So we're humanizing the dog.
We're humanizing the dog. The dog will not just go out alone.
I'm sorry, sir. Could you pull the mic closer just so other people can hear too?
Thank you. The dog will always have a handler, and they're not almost never let out on their own without a leash. The exceptions might be a barricaded subject where they're in there and they have already made a threat to others around them and things of that nature. Adequate warnings would be given that if you don't come out and give up, then you would be subject. We're going to let the dog in. So if you were to hurt the dog, then you know that it's a police-related situation, so they would be an extension of the police officer. I don't know that we're humanizing the dog, but they're an extension of the police officer, and they're on duty at the time.
I see. Except that you can rationalize with a human, but you can't with a dog.
Oh, you mean you
Once
couldn't say,
you let go of the dog will attack. No question about it.
When I've gone out to dog training, and I'm not a dog handler, but when I've gone out to dog training, if you stop and desist from any type of activity, for the most part, the dog doesn't attack you. It's when you do run or you do try to fight with somebody and things like that. I can't raise my right hand and say that happens every time because there's things that go on, but the dogs are trained, and I have caught dogs every once in a while years ago. And as long as you give up, the dog will hold you, but they're not going to, try to bite you and stuff like that.
Okay.
And the dogs are very expensive. Just so I didn't get that in. But they're like $20,000. So they're really expensive because they're trained, and I know maybe I shouldn't have said that. But they're highly trained, and they have different activities that they do. And so we only use breeds that can handle the training and education also.
Thank you, Mr. Lefkencourt.
Right, members, any other questions? Okay, and if not, moving on. House Bill 238 relating to witnesses. This would amend HRS 621-7 to increase the per diem payments for out-of-state witnesses in criminal cases from $110 to $145. It would also provide an additional $90 per diem payment for witnesses from any island other than the island on which the court is located when that witness is required to stay overnight. First up, we have the Department of Budget and Finance. Okay, providing comments noting that if this proposal is approved, they need additional costs. Otherwise, if no funding is available, this bill will not be able to be moved forward. House Bill 2, Crime Victim Compensation Commission.
We'll stand for our strong testimony supporting this measure.
Thank you, Ms. Ferguson-Bray. Prosecuting Attorney. Honolulu.
John Karamatsu, Deputy Prosecutor, Honolulu, and with me is Dennis Dunn, Director of Victim Witness Advocacy in our department. We strongly support this. This is one of our package bills, one of our 11 measures that are moving in the legislature. The impact, I was a little generous when I typed this out, but I just got some numbers that's more exact. We're looking at a fiscal impact of $3,333.75 with the additional costs. These are witnesses that we need to hopefully, to convict the crimes that being placed on our victims. And what we're doing is, it hasn't been changed since 1989. It's statutory set. So 89, which is 24 years ago, was the last time, and these numbers are still the same. And the effects for providing lodging and food has increased over the last 24 years. So what we're trying to do is just try to make it up to par with current times so that we can bring these witnesses, and we don't want to lose a case because we can't afford a witness, or it's an economic barrier for the witness to come here. And sometimes witnesses take money off of their own pocket. So, this would help us in addressing that issue. And I guess, Dennis, you can give a perspective from your...
Just quickly, I just wanted to make a plea for your support for this. We've been trying to make this change for 10 years. The costs have increased. The number of witnesses that are reluctant to come has increased substantially. A number of these individuals are residents of Hawaii who had to leave because Hawaii is so expensive. And then we have them come back, and they're basically bearing the costs of the prosecution themselves. They're helping represent all of us by testifying against some of these serious criminals. Yet we're providing an amount of money that's certainly not sufficient for them to be able to certainly even get a hotel room anymore. And all as we estimated the cost, and it's pretty accurate here, based on the number of witnesses we had last year that returned and the amount of per diem hours that were paid out. This would only be an additional cost of $3,300 basically. And we just can't see why we should be jeopardizing important criminal cases for the lack of $3,300. Doesn't make sense.
Okay. All right. Thank you very much, gentlemen. Prosecuting attorney from Kauai. In support, Director Loretta Fuddy, Department of Health. Appreciates the intent but recommends changes. Crime Victim Compensation Commission. Oh, sorry, Pam, I've already got you here. Office of the Public Defender. 238. Sorry, 236? 236. I'm sorry, 238. I'm sorry.
We switched over. We were on 236.
Oh, sorry. My numbers are, sorry. Okay, that's all the written testimony I have on House Bill 238. Members, are there any questions? Chair?
Former Chair Karamatsu. I've read the bill, but I'm still not quite sure where the money actually comes from. Which budget does this money? Will this money come out of?
Is it from you guys' general funds?
General funds from through the state or from?
Yeah, state.
Okay.
Yeah.
So basically, you're asking us to allow you to raise the fees that the county will have to pay.
This is all statute, so statewide, how much we're allowed to give each.
But the money comes from the counties.
No, money comes
from the state.
to the Department of Budget and Finance directly reimburses the counties for the cost of per diem.
Okay, but which budget is it through? Do you know, the judiciary budget or
directly through the budget and finance? From their budget.
Okay, so it's a
department.
It's the executive branch.
Yes.
It's the executive budget.
Correct.
Okay, thank you. Just curious.
Members, any other questions? Stay here. Members, any other questions? Vice Chair has a few questions. Mr. Karamatsu, I understand that you're asking for this increase and that you folks have been seeking this increase for over 10 years, Mr. Dunn. What exactly do they get? What does per diem cover? A daily per diem cover?
There's lodging and food, and I guess Dennis, is there any other things?
Lodging, food, and any incidental expenses that are relative to their need to subsist while they're here.
Okay, and then, so let's just say, when you talk about lodging, have you folks ever thought about trying to get a deal with Outrigger and trying to get it? So you already have that. You do already have that, kind of like what our
program. What used to be called the Green Light program.
Okay, so you do in fact use that.
Possible rates.
Okay, but I just want to make sure. Let's just say theoretically, if this bill were to move forward and were to pass into law, Could there ever be a windfall for a particular witness? Let's say, I mean, so it would only be the exact amount that they spent. It wouldn't be, so even if we increased it to $145 per day, let's say they were only spending $130 a day, we wouldn't give them the full $145, right?
Well, we're required to give them whatever's in the statute, so yes, they could get the full 140.
So they could potentially make money.
Kind of like
Well, they're only here for a few days, maybe 2 or 3 days.
Can you put the mic closer to your
How
mouth?
much money could you make? And the expenses that they're incurring, you know, the hotel room alone is going to be close to that amount of money, so
What's
I'm
the
not sure.
hotel room cost? Because I know, like, for example, legislators, when they stay at Outrigger, there's a special deal, a special rate that they get.
I believe at our current rates, we don't have anything that's any lower than about $110 a night.
Okay.
And that's only for the lodging, doesn't cover your food.
Okay, and what's considered incidentals?
You know, like toiletry articles or whatever they need to subsist while they're here, take care of themselves. Because they're away from home. They don't have their normal things that they would have.
Okay, so they wouldn't bring a toothbrush with them or toothpaste or...
Well, they might.
Okay. But what do you guys define as incidentals? I'm just trying to understand, again, what the per diem costs. I can understand lodging and food, but I'm still... But again, what if they want to eat at Roy's, just theoretically, you know, hypothetically speaking?
I don't think they would have enough money for that.
I don't need the cover charge.
Okay, so, but again, incidentals...
We're not talking about anything. It's basically anything that they would be required to essentially stay in Hawaii while they're here, right? It's just the basic things that would cost you to do whatever you might need as your basic costs.
Okay, so does this include, let's say, a car rental, gas?
If they want to do that, they can do that, but I have to cover it all with $145.
Taxi.
No matter what it is.
Maybe cheaper. Taxis cheaper.
No, actually they do get reimbursed separately for mileage. So if they were to
So
travel
that's separate
from their hotel to them, the court has a arrangement to pay them for their mileage and pays a witness fee also.
Okay, so that's actually separate outside of this per diem cost.
Correct.
So they could still be reimbursed for that. Okay, I'm sorry, Mr. Carlon, so talk about the numbers again. What were you saying was the total? What did you...
Well, the additional cost is $3,333.75. Currently in 2012, we spent, this is currently $11,082.50. That's last year's expenditure.
From 2012?
I believe that's on approximately 95 per diem days.
Okay.
So that we're reimbursed.
We're expecting about a total, if you add the extra 3,000, about 14,000, 15,000. But I was very generous in my estimates. Yeah.
Okay.
Yeah.
Great. Thank you. All right. Members, any other questions? Okay, seeing none, moving on to House Bill 236 relating to the rights of victims, amends Crime Victims' Bill of Rights to include notice as to an offender's unfitness to stand trial, transfer to the state hospital or other psychiatric facility, or regaining fitness to proceed. Requires the Department of Health to provide notice of an offender's authorized absences to the Department of the Prosecuting Attorney in the county where the crime was committed. First up, we've got the Department of Health.
Good afternoon. Vice Chair Howard, Chair Rhodes, committee members, representatives. I'm Mark Fridovich. I'm the administrator of Hawaii State Hospital. I'm here on behalf of Director Fuddy. The Department of Health appreciates the intent of this bill, but recommends several changes to reduce redundancy and improve clarity. If the bill is implemented, it is enacted as written. There's unspecified additional work hours that may be required. The intent of this bill to improve timely and effective notification of victims of crimes or relatives is consistent with our department's goal of improving community safety. The department empathizes with victims, and through our programs, we take steps through outreach, treatment, and prevention. Our concerns come from sections of the bill that appear to create ambiguity or redundancy and may be in the way of more efficient and timely notifications. 3 parts of the bill. First, we agree that if there is an unauthorized absence, for example, an escape from Hawaii State Hospital, the Department of Health should have the responsibility to notify the prosecutor's office of this fact in a timely manner. As specified in the bill, page 4. Although we provide a courtesy notice to the prosecutor's office of any authorized absence, we support this portion of the bill. There are two portions of the bill which we do not support. First, our understanding of Hawaii Revised Statute Section 334-60.7 already requires the Department of Health to give notice to the prosecutor's office when a patient is discharged from involuntary civil commitment, as specified in the draft bill. Prosecutors are present at most, if not all, hearings under Chapter 704 and 406, and thus have timely notice of the results of these hearings. However, once a defendant has been civilly committed to the hospital, a court order is not required prior to hospital discharge. The section of the Hawaii Revised Statute 334-60.7 requires notice to relevant parties, which include the prosecutor's office and defense attorneys. They are routinely notified by the Department of the Attorney General on behalf of the Department of Health and Hawaii State Hospital of the intent to discharge from civil commitment categories listed. It's unnecessary, we believe, and redundant to require DOH personnel to inform the prosecutor's office of these situations twice. Secondly, it's our understanding of Hawaii Revised Statute 334-5 and Chapter 704 and 706 that when a defendant is committed to the, quote, custody of the Department of Health to be placed in an appropriate institution for detention, care, and treatment, the defendant can only be committed to a locked, licensed psychiatric hospital or a psych unit within a licensed hospital. Therefore, the additions to Section 801D-2, specifically page 9, lines 6 through 13 of the proposed bill, and specifically sections B, I, and B, III, have no clear meaning or operational significance. We recommend that these be removed. Thank you for the opportunity to testify on this bill.
Thank you, Mr. Fridovich. We have the Crime Victim Compensation Commission. Ms. Ferguson-Bray.
We'll stand on our testimony in support of this amendment.
Okay, thank you. Office of the Public Defender. Mr. Tanaki.
Thank you, Vice Chair Har, members of the committee. We have concerns about HB 236 to the extent that disclosure of some of this information may violate confidentiality laws. And I was specifically referring to HIPAA. However, I was told by the Department of Health personnel that the state hospital is not a covered entity under HIPAA, but perhaps Dr. Fridovich can better answer these questions than I, because it involves notice to some of the provisions of this measure. I think when a person is on an unauthorized absence, that's usually a matter of public record because it becomes subject to the court proceedings. But it also involves notice to victims through the prosecutor's office regarding changes in major developments in the case, such as findings of unfitness to proceed and various legal findings like that. And to the extent that there's no specific protections against disclosure of medical conditions or what might be protected health information, we do have concerns. And we believe that our concerns are well-founded because oftentimes you'd be surprised what people who are victimized put on Facebook and internet type of dissemination. So I mean that's their personal prerogative, but we're very concerned about confidentiality. Now there is a clause in here saying that nothing in this section shall preclude the application of more restrictive rules of confidentiality set forth for records covered by Title 42. I don't know that that's specific enough, though. I think there needs to be specific guidelines on what can be disclosed to victims and what the prosecutor's office should keep confidential or the hospital should keep confidential. But those are our concerns about it. Thank you.
Okay. Thank you, Mr. Tonaki. The Department of the Prosecuting Attorney, City and County of Honolulu, Mr. Kawamatsu. Mr. Dunn.
Vice Chair, members of the committee, John Carr, Master Prosecutor, Deputy Prosecutor, and also Dennis Dunn, advocate for the witnesses. Mainly, for this is when an individual, when the offender is out of the facility, we just want to know if they're out. We don't want to know why. We don't want to go into those details. We just want to know they're out. And policy reason is we want to protect our victims, especially if it was a violent type of situation where there's a potential where our victim could be in trouble or in danger, or even, you see some cases where you see that the guy's out and then kills a girl. Usually violent kind of situations. So we just want to have that opportunity to protect our witnesses and make sure she can get away or he can get away to a safe location or whatnot, get the proper services, and Dennis can better explain.
Well, essentially what we're trying to do with that, we really want to know, are they in or are they out? That's it. We don't need any additional information, as John referenced. I think the important thing here is that there's an important subset of offenders that this really applies to. It's true for those individuals who have been acquitted based on insanity, that the prosecutor's office does get regular notice of upcoming hearings and whether or not the person potentially be released. But for those people for whom they've been found unfit to proceed and then subsequently the case is dismissed, we are no longer a party to that proceeding, and there is nothing in the law which requires us to be notified. And those are the specific individuals that we're concerned about. And some of those are, unfortunately, some of the most dangerous offenders. And that's really just the limited population that we're looking for. It's small enough that this should not provide any additional burden with any kind of increased cost. And I can assure you that, at least for our county, the calls can just simply come directly to me, and I'll notify victims the same way we do when the public safety releases someone and we have a request on file to notify them. It's done very easily and simply, and there's no real difficult or complicated process. And if this change isn't made, I did confirm again today that that particular subset of cases are not being reported to our office.
And just real quickly, there's an immunity clause for civil actions and no penalties. It's just merely trying to keep the departments working long after me and Dennis are gone.
Thank you. Okay, next up we have the Office of the Prosecuting Attorney, County of Kauai, in support. City and County of Honolulu, HPD. In support? Yes. Okay. The Hawaii State Coalition Against Domestic Violence. Veronica Geronimo. In support? That's all the written testimony I have on House Bill 236. Are there any other persons wishing to testify? If not, members, any questions? Sheriff?
Yeah, I've got a couple here. Let's see. I guess for Mr. Kiramatsu, and I think maybe you already addressed this to a certain extent, but in terms of the time frame, some of these people stay in the mental hospital for quite some time. I mean, like 10, 12, 15 years, right? So the question is, I guess, do you guys keep up the records of where people, do people let you know where they move when they move with the victims' families?
I think that Dennis, since he's in charge of that, can better answer that.
Yes, we do keep those records on criminal cases. For example, I've notified people 30 years after someone was convicted and gone to prison.
So the mere passage of time is not a problem?
Well, it's a challenge, but we also have access to a variety of different databases that allows us to be able to fairly easily search for individuals and locate them should they move.
Okay. I guess for a public defender's office, in your written testimony you had some HIPAA concerns. Doesn't HIPAA, I mean, HIPAA is going to apply whether we want it to or not, doesn't it?
Yes, it will. But, an example...
I'm not trying to specifically put out a bill that, is contradictory to it, but on the other hand, even if it were, it doesn't really matter because HIPAA trumps.
It would trump it. However, we're even in the court rules these days, we're very careful about we need to comply specifically with certain guidelines for even filing documents in court.
And that's all placed in a rule because of the concerns about HIPAA. I mean, my concern is, I understand that the victim a lot of times just wants to know why the person is in or out of the hospital, or when they're in and out, but sometimes they may be notified that, say, the person is unfit to proceed, and then they may start pressuring the prosecutor, like, well, why is he unfit to proceed? He's perfectly fine when he was assaulting me or whatever. And you don't want you want the parties to have clear guidelines about what they can and cannot disclose. In other words, can't go into that, well, he's now testing for schizophrenia and receiving this medication, that medication.
Okay.
So that's the gist of our
thank you.
Yeah.
And then again for Mr. Dunn or Mr. Karamatsu, regarding the prosecutor's proposed amendments, it sounded to me like you wanted to drop if the defendant goes through the court system and they're just acquitted, period, and then for whatever reason they're civilly committed.
In those cases, there's already a procedure provided for.
Okay, so that's why you
in law that we're notified.
That's why you wanted to drop that out of the.
That's why you occasionally will see some of the more notorious offenders who've been acquitted by insanity will be coming up for a hearing, and then we're there, often opposing their release.
Okay, but so what you're saying is this law doesn't need to address that because it's already taken care of.
Correct.
Okay. Yeah, that's it. Thank
Okay,
you.
members, any other questions? Vice Chair has a quick question. Department of Health. And Ms. Ferguson-Bray. Mr. Fridovich, in your written testimony, in the department's written testimony, you recommended deletion of 2 sections of the bill, basically to reduce redundancy and improve clarity, something I'm a big fan of doing, as are many members of this committee. And I just want to make sure Ms. Ferguson-Bray is okay with that.
Since it's the prosecutor's bill, if you could join me.
Yeah, because you're Convict and Compensation Commission, I just want to make sure it would be okay with you. So essentially what the Department of Health is saying is that they say there are 2 portions of the bill which they do not support. This is on page 2 of 3 of their testimony. They're saying that HRS 334-60.7 already requires the Department of Health to give notice to the prosecutor's office when a patient is discharged from an involuntary civil commitment. And then they say prosecutors are present at most, if not all, hearings under 704 and 706, and thus have notice of the results of these hearings. However, once a defendant has been civilly committed to the hospital, a court order is not required prior to the hospital discharging the patient. Therefore, 334-60.7 requires notice to the relevant parties. So in other words, he's just saying this section is already in statute, correct? Mr. Fridovich?
That's our understanding, yes.
Okay. Is that your understanding, Pam?
Well, because I'm not familiar now with what's happening with the prosecutors.
Okay.
It's already in statute.
Mr. Kalamatsu?
That it's not probably.
Or Dennis, Mr. Dunn, do you want to come on up? Because the Department of Health is essentially asking us to take out 2 portions of this bill. And if that, because they're claiming, because it's essentially redundant, because it's already in statute. So I just want to make sure that that's...
They're saying they're interested parties, but what we've been informed of in the past is because the case has been dismissed, the criminal case has been dismissed, there is no criminal case, unless it's dismissed due to acquittal based on insanity, that there's no obligation. That they're not permitted to give us that information. That's what we've been. This year is the first time we've ever heard a claim that it's already provided for, because we've always been told before we couldn't get that information, which is why this legislation came forth. Now there have been recent claiming that we are getting notification, and I've checked with virtually everybody in our office. I mean, I've sent emails around and checked individually with the people who already received this kind of information, and they say, as far as they know, this particular subset that I was referring to is not covered under the law, and we are not notified.
Okay, Mr. Fridovich, do you want to respond?
May I, if there's a subset for which this is not occurring, it may be beneficial that we focus the proposed bill on that specific subset. I've checked for what I understand this bill to cover, and we're providing notice as outlined for 334-60.7. If there are other individuals, such as Prosecutor Dunn, have identified where it's not occurring, It's not what this bill says. I think we're in compliance with the law as written here, HRS 334-60.7. And if there's some other group to which the notification requirements should pertain, perhaps the bill should be amended so as to focus on that specific group. I've heard the counter. I've looked, and I can't find that we're not providing notice per the current requirement. So again, I'm not saying it never happened, and it may be that the law, a bill, should focus on a specific group where there's currently a gap. I'm not seeing it in what's proposed here.
Okay, so prosecuting attorney's office then, I mean, I'm looking at 334-60.7, and it clearly does require notice. So I just...
To whom? To the parties. We're not a party to that civil commitment.
The administrator shall provide notice of the patient's admission to voluntary inpatient treatment. The notice shall be filed with the court and served personally or by certified mail on those persons whom the order of commitment specifies as entitled to receive notice.
To those who are committed, not who are released. We're asking about notification when they're released. That's what the issue is.
And again, in terms of what's proposed here, we believe we are providing that notice.
Pursuant to the statute.
That's correct.
Okay, but Mr. Dunn's contention is that the statute doesn't address their group.
And it may be that there is some other group, it's not specified in this bill, that the statute should be extended to. I'm not seeing it, and in my review, I haven't encountered it.
Okay, and then the second part of your testimony, Mr. Brdovich, that you're requesting be deleted?
The final part of the bill on pages of the draft HB 236, my copy, I'm going to say it's page 9. Excuse me. Yes. This BII, it's curious and ambiguous to us. It says, committed to the custody of the Director of Health for placement in an appropriate public or private institution, including state facilities established under Chapter 334. That's fine. We're all set. Psychiatric facility, fine. Stop. Special treatment facility or therapeutic living program. Here's where the problems begin. Our understanding is that there's no such thing as commitment to custody to the Director of Health for placement in a special treatment facility or therapeutic living program, or follow on, III below, any other public or private facility or institution, whether on an inpatient or outpatient basis, for the care, custody, diagnosis, or treatment or rehab of that person. That would pertain, our reading is that that's very unclear, and arguably could pertain to any community residence, outpatient facility. And first of all, it's not our understanding that a person could be committed to such a place, at least not to the custody of the Director of Health. But that's it. So we recommend, for your consideration, potential removal of that section, because we don't think it makes sense legally. I'm not an attorney. But our application of it would be very difficult.
Okay, Mr. Dunn.
We have no problem with that.
Okay. So then getting back to that first issue, can you two work it out in terms of trying to find some language that would be palatable for both, and then let Ms. Ferguson-Bray sign off on it? That would be good, because I think everybody's looking for everyone's on the same page. We just got to figure out the language that will be palatable for both parties.
We are certainly willing to do that.
Okay, thank you very much. Thank you, Chair. Any other questions, members? Okay, seeing none, moving on to House Bill 249 relating to domestic abuse, authorizes as a condition of probation electronic monitoring of persons convicted of violating a domestic abuse temporary restraining order or protective order. Okay, first up we have Office of the Public Defender. Mr. Tanaki.
We oppose passage of HB number 249. There's two very serious concerns we have. The first is the establishment of a geographic exclusion zone around the protected party. Currently, when there's a violation of temporary restraining order, the court has the ability to order the defendant or the offender to, on a no contact order, to not contact the complainant. This would create a zone, and the court can define how large that zone is, enforced by global positioning satellite GPS. And the problem with this is that oftentimes we find that the parties to TRO live in the same parts of town, so it could have the effect of excluding someone from their home. The courts require our clients to maintain their jobs so that they can pay child support or maintain a household or support the ex-spouse or ex-partner, and there are problems with that. For instance, if the person works as a delivery driver, has to go into certain areas of town, or the person works in that exclusion zone. So currently we feel that the no contact order is sufficient. Creating this zone would create a lot of problems in terms of residents and employment potentially. The second concern is this GPS. Now, I guess currently there is no facilities or no equipment for this GPS, so the bill calls for basically the offender to bear the cost of such a system. And we don't know what this cost would be, but we feel that it'd be very impractical to begin with, and even unreasonable to say the assessment was a couple $100s a month. I think you'd be very unlikely to see such payment made by the majority of public defender clients who are already having a hard time with daily necessities such as food, clothing, and shelter. So where the money is going to come from to maintain this 24/7 GPS monitoring, equipment, staffing to make sure it's enforced, we think is problematic. But those are two big concerns. Thank you.
Okay, thank you, Mr. Chinaki. Domestic Violence Action Center. In support, Hawaii State Coalition Against Domestic Violence. Supports the intent, however concerned with many competing priorities for state funding, that this may not be the most cost-effective use of state resources. Christine Johnson. In support. Late testimony from Ala Kuola, Kim Sasaki. Good afternoon.
Good afternoon. Good afternoon, Chair Rhodes, members of the committee, Vice Chair Hart. My name is Kim Sasaki, and I'm with Ala Kuola. We're a non-profit agency, and we assist domestic violence victims in obtaining temporary restraining orders. We support the intent of this bill, though we do understand that there are certain concerns about the geographic exclusion zones and also the resources to implement the electronic devices needed to do this. But we feel that this definitely has the ability to save lives. And, we see victims every day. We see and we hear what they go through, and we think this could be really important.
Good afternoon, committee members, vice chairman, and chairman. My name is Paul Keller Ahmad. I also work with Ala Kuola. I'm one of the court officers and intake specialists there. And as Ms. Sasaki stated, we have victims that come in to file a TRO with us, and they inform us that not all the time are they protected through just the protective orders that the courts issue, because the perpetrators or the respondents still tend to violate the orders and come within a prohibited distance or they tend to follow our petitioners where they work or where they where they work or where they live, and kind of, in a sense, stalk them. And our victims always come back to try and file a motion to extend their orders for their own protection.
Okay, great. Thank you very much. Thank you for being here today. Are there any other persons wishing to testify on House Bill 249? If not, members, any questions? Chair?
No, go ahead and take it. Any other questions? Okay, seeing none, let's go ahead and move on to HB 239. This bill will require an adjudicated minor to make restitution payments to the victim if the victim requests it. First up, we have Office of Public Defender. Turn it again.
The main problem we have with this bill is the removal of the discretion of the family court to order restitution. Restitution, we feel, should depend on the facts of the particular case. Oftentimes in family court, what we see is a child who might be subject to bullying and that kind of thing at school who acts out, and then maybe punches another kid in the face, and then the kid, asks for restitution. So, I mean, that's just an example of a case where the judge might determine that the victim is really the one at fault, and it should be up to the individual judge whether to order the restitution, rather than this would make it mandatory for restitution upon the demand of the victim to order it. So.
Great. Thanks very much. Next up, we have Crime Victim Compensation Commission.
Thank you very much. Good afternoon. Pam Ferguson, from the Crime Victim Compensation Commission. I strongly support this measure. As you know, the Crime Victim Compensation Commission provides compensation to victims of violent crime, and we also run a program to collect restitution from inmates and parolees. And also we collect restitution as reimbursement when we've paid out compensation. So we've opened about 4,000 restitution cases, paid over $1.8 million to crime victims, so we're very knowledgeable, although those are adult offenders, about how important restitution is to crime victims and their sense about whether or not that they receive justice through the system. So we fought for many years to make restitution mandatory for adult offenders. It wasn't until 2006, many decades after there was even a possibility of getting restitution through the system, that it was mandated that adult offenders pay restitution to crime victims. And it's only for their crime-related expenses. So we strongly support this measure, and we think that it's clear that not only is restitution a benefit to victims, but it's also been shown, particularly in juvenile offenders through a study, that paying restitution does reduce recidivism for juvenile offenders. So I think it's particularly important for juvenile offenders. There's a very strong correlation between taking money out of your own pocket to right the wrong that you've committed as a juvenile, and rehabilitation and the understanding that what you've done is wrong. So we strongly support this measure. We have a couple of proposed amendments to actually make this provision parallel to the adult restitution provision. I don't believe there's a definition of victim under the juvenile provision, and so that definition should include not only victims, the actual victim, but surviving family members, so in case there's a fatality that will often ask for restitution to pay for things like funeral expenses. Also, we stand in the shoes of the victim when crime victim compensation is paid, so that we are repaid with restitutions, and that money is then recycled back to other victims because they're specially funded, so that we continue to have funding available to pay crime victims. So those are the two proposed amendments we have, and we strongly support this measure. Thank you very much.
Thank you very much. That's all the written testimony we have. Anyone else wishing to testify on HB 239? Yes, former Chair Karamatsu.
We submitted actually for this bill and proposed HD1. If not, we can provide the HD1. Basically, we have an HD1 that clarifies, and there's a lot of technical amendments, and mostly clarifies what we want, basically. And we also want to include some of the proposed language that CVCC has, referencing victim to Section 70646, also reasonable and verified losses, suffered by the victim or victims. And in our proposal, once you get it, you'll notice there's some grammar changes just to make it more clear. And we also include upon requests, not just upon request on the victim, because attorneys make requests for the victim. We also included party or person, which is right now currently in the statute. We just want to keep that language the same instead of changing it, so it's upon request for restitution to any victim, party, or person. So we just want to keep that the same. Other than that, I think that's all the major changes.
And just to clarify, there's another, a lot of juvenile cases go by way of informal adjustment. When juveniles first come in, they won't make their way through the system, and there's an attempt to informally adjust the case. And so we want to make sure that there's an amendment to include those types of cases as well that are informally adjusted under some of the juvenile provisions rather than adjudicated. So that those ones, offenders have to pay restitution as well.
Sure.
Provision 571-314, I think, is the right provision, but I'll go back and verify that.
And Chair, I have a clean copy of the testimony as well as the proposed draft that can be distributed.
We'll take it. Okay, anyone else wishing to testify on HB 239? Seeing none, members, questions? Ms. Bray, Ferguson Bray, you mentioned that you were trying to align the juvenile situation more with the adult. Is restitution mandatory in the adult situation?
Restitution is mandatory. In 2006, restitution became mandatory in adult criminal cases.
Okay, so judge has no wiggle
discretion.
room. Okay, thank you.
Thank you.
Yeah, sure, Representative.
Go ahead, Representative.
The synopsis here says that the parents can be held liable.
Yeah, the current statutory provisions provide that parents can be held liable. And so it doesn't change that. I think it just merely incorporates that into a singular provision. So,
do you think that's appropriate?
Yes, I think it is. And I think that, like as I said, it's already part of the original provision. So it's deleted, I think, from page 8, and then it's then placed in this provision. So, but it's mandatory.
What if you have a child that doesn't listen to you? I got 8 kids. One of them's brain dead. Okay, so what happens when they don't listen to you?
Well, I think really what we're talking about is crime victims. Is making sure that the crime victims in these cases have the financial justice they deserve. So I think on one side where you're